Hello, my name is Brant Hunt. My channel is Discerning What is True. Um, I'm going to be reading from a book by Eustace Mullins tonight. The book is titled Rape of Justice. We'll be going through chapter 10 tonight, try to. And so I am live tonight on Facebook. I am also live on YouTube and also Odyssey. So let's get into the book as we continue to read The Rape of Justice by Eustace Mullins. Chapter 10, The Strange Case of the Schizophrenic Driver. In 1979, the war of attrition against me was intensified by federal officials lurking on my home front. I was arrested and charged with driving 50 miles per hour in a 35-mile zone. At the time, I was driving about 4 miles per hour, trying to locate a side street in which I wished to turn. I was convicted and fined in a local court. At the scene was described in a letter to the local newspaper under the heading Shades of the Old West. Admirers of the code of the Old West and the rough and ready six-gun justice administration by such courts as Judge Roy Bean might not realize that this era has not yet vanished from American life. I had a taste of it when I answered a speeding charge in the local court. Although my case was posted at first on the docket, I sat on the bench for 3 hours while every other case was heard. The court was then cleared of civilians, that is, anyone who might later corroborate my version of events. Apparently, I am reputed to be very dangerous, as I gave my testimony in an otherwise empty courtroom, surrounded by heavily armed bailiffs. The nearest 35-mile-per-hour sign is 1.1 mile away, but a 55-mile sign is clearly visible where I was stopped. The officer falsely testified that the 55-mile-per-hour sign was out of sight on the other side of the hill. Judge Roy Bean, where are you? I sued the mayor and the chief of police, who then answered under oath that they had no responsibility for the actions of any policeman in the city. They requested a bill of particulars, which I filed, stating in part, 1. As a chief instigator and prosecutor of government officials to the Nuremberg trials in Nuremberg, Germany, the federal government of the United States firmly established a legal precedent, the precept that officials such as city mayors and police are wholly responsible, actionable, and liable under a law for acts committed by their agents and underlings, whether said officials had specific commission and required such acts from and said underlying or not. And the federal government of the United States convicted said officials and exacted the death penalty, although none of the said officials had personally participated in the act of which they were accused. The interested defendants, while not personally present at the scene of the acts of assault against the plaintiff, did commission, instruct, uniform, and sent forth yon arresting officer to commit said acts against plaintiff and defendants by the preceding establishment as law at the Nuremberg trials, by numerous other legal precepts, are wholly and fully liable for acts committed against plaintiff by their officials, commissioned and assigned and instructed uniform agents, according to the precepts of the Nuremberg trials. Defendants are wholly and legally liable and answer for impeding plaintiff progress on a public street. And the defendants have no evidence and cannot exhibit any evidence that the plaintiff was in violation of any law when his progress was impeded by an armed agent of the defendants on a public street. This case also dragged on for some 3 years. Much of the plaintiff's complaints was printed verbatim in the local press. An interesting development occurred when the judge refused to grant a dismissal as insufficient cause of action for the city. He was exiled to a remote village where presumably he remains today, that is, a ringer, was brought in on the day of the trial as a more malleable substitute. He allowed me to testify and then granted a motion to dismiss by the city attorney. He banally announced that I now had had my day in court, a half hour having elapsed since the trial began. I filed a motion to vacate judgment, which was routine denied. The next section, motion to vacate judgment. Now comes plaintiff Eustace C. Mullins, a attorney pro se, and respectfully moves the court to vacate the judgment of February 11, 1982 in this section on the following grounds. Number 1, 49 Corpus Juris Secundum 265, court of record or a general judge jurisdiction have inherited power to vacate or set aside their own judgment. This is based upon Pavelica, this is spelled P-A-V-E-L-K-A versus Overton. CIV.APP 47S.W.2D369. 2. 88 Corpus Juris Secundum 139. A motion to strike evidence is premature if addressed to evidence, the competency of relevance of which may thereafter be made to appear. Kiefer versus American Stores Company 184A.795, 116, New Jersey, LAW 437. And plaintiff disposes that the competence and relevance of his testimony would have been corroborated by the testimony and subsequently cross-examination of the defendant in this action, and that the premature motion of the defendant to strike plaintiff evidence and dismiss this action prevented plaintiff from curing any defects in his evidence. 30A Corpus Juris Secundum 262. Equity. Defects cured by subsequently pleading proof of proceedings aided by the evidence. Kemp versus Kemp 63 SO dot 2D 702, 703, 258 ALA dot 570. 3. 88 Corpus Juris Secundum 143. A motion to strike evidence is too broad, where a part thereof is admissible, and the motion does not point out specifically the particular part objected to. This is based upon Palaracio versus Propel 84 8.2D 11, 16 NJ Super 128. And plaintiff disposes that defendant motion to strike was too broad and flawed, and that it did not specifically cite any parts of plaintiff's evidence as grounds for said notion. Number 4, 88 Corpus Juris Secundum 144. Unless the right to have the evidence stricken clearly appears, the court is not bound to strike it. This is based upon Scarlett versus Young 183A.129, 170 MD.358. And plaintiff disposes that defendant motion to strike being flawed, the court was not bound to grant it. Number 5, 88 Corpus Juris Secundum 134. As a general rule, evidence competent for any purpose and relevant to any issue should not be stricken. Lewes, spelled L-E-W-E-S, Sand Company versus Craves, C-R-A-V-E-S, 8A.2D 21 1 Terry 189, period. The fact that evidence does not come up to the offer of proof, provided it is material, does not constitute grounds for striking it. Smith versus Martin 106A 666, 93 BT.111, period. And plaintiff avers that his evidence was competent and relevant to the issue of this issue, and that it was material, and that it should not have been stricken. 6. 88 Corpus Juris Secundum 237. A motion to strike or exclude all the evidence sanctioned under the practice of some states. It is the nature of a demurral to the evidence and had the effect of such a demurral insofar as it tests the sufficiency of the evidence. This is based upon McCall-Densmore Company versus Stevens. 194P.243.59 MONT.206, 64 CJP 390 Note 62 period. It must be tested by the same rules as demurrer to the evidence. Hockley versus Dawson, 18P.592, 16OR.344, comma. A motion to strike all evidence of the plaintiff from the record on the ground that the petition had failed to show a cause of action is not the equivalent of a motion to dismiss, with a statute providing for such a motion after plaintiff had completed presenting of his evidence. Monday, M-U-N-D-A-Y versus Austin, comma, 218 S.W.2D 624, comma, 358 MO.959, period. And plaintiff disposes that defendant had previously submitted a demurrer on the same grounds and that the court had on September 14, 1981, denied defendant's demurrer. 88 Corpus Juris Securium 235. Demurrer is properly overruled where the petition is sustained by competent evidence. Cargill Commission Company versus Mowry, M-O-W-E-R-Y, comma, 161 P.634, comma, 162 P.313, comma, 99 KAN.389, period. Thus, we have a situation where plaintiff evidence is ruled competent on September 14, 1981, and the same evidence is ruled incompetent in the same court on February 11, 1982. Number 7. Demurrers are no favor of courts of equity. Harlan versus Lee, 9A.2D 839, comma, 177 MD.437, period. Plaintiff, after defendant motion to strike his evidence, pointed out to the court that defendant motion was in the nature of a demurrer, as cited above in paragraph 6, and that said demurrer has already been denied by the court. But the court took the position that defendant motion to strike was not in the nature of a demurrer, and plaintiff praised the court whether its decision on September 14, 1981, denying the demurrer should not take procedure over its decision of February 11, 1982, to grant a motion to strike plaintiff's evidence, said motion being in the nature of demurrer. Number 8, Corpus Juris Securium 237. A motion by defendant to strike plaintiff's evidence should be reserved until plaintiff has rested his case. Burke versus Gale, comma, 67 S.E.2D 917, comma, 193 BA.130, period. And plaintiff did not state that he had rested his case, as plaintiff was expecting to make more of his evidence explicated to the jury during the cross-examination by defendant, which cross-examination was not forthcoming, and by plaintiff cross-examination of the defendants, and said motion by defendants to strike plaintiff's evidence, which was not complete, constitutionally denied a due process. 16A, Corpus Juris Securium 591, period. Suppression of evidence may be a denial of due process where it is vital evidence material to the issue of guilt or penalty. Thomason, versus People, comma, 102 N.E.2D 315, comma, 410 ILL, period 256. Number 9. Defendant's motion to strike plaintiff's evidence to dismiss this cause constituted irregular judicial proceedings because plaintiff had no prior notice of defendant's motion or any other opportunity to prepare to argue it, although said motion does not in itself constitute surprise in its judicial definition. In this instance, it is definitely qualified as surprise because plaintiff, having already seen defendant's demurrer denied by this court, had no occasion to expect or to prepare for a motion to strike plaintiff's evidence, which was in the nature of the demurrer. Number 10. The declaration, complaint, or petition, or account thereof will be sustained if it's good on any theory. City of Madison versus Drew, 265 N.W.683, comma, 220 WIS.511, comma, 104 ALR, all caps, 1387, period. And plaintiff avers that he was and is prepared to sustain all counts of his petition before a jury. In his opening statement to the jury, plaintiff stated that the jury would be asked to decide fundamental features of our civil law, including the question of agency, violation of civil rights, involuntary servitude, the right to due process, the right to equal protection of the law, and the consideration of whether admittedly hearsay could be accepted as valid evidence. Yet the jury was not allowed to consider or decide any of these questions. Number 11, defendant's motion to strike plaintiff's evidence and to dismiss this clause was based on the claim that defendants had no connection with this crime, which in effect denied the entire body of civil law, which enumerates the doctrine of agency. The master made the pledge of his servants. Alms, Quilt, Savidius, Haven, Edward the Confessor, BRCT FOL .124B . Quote, if I make a deputy, I'm always officer, and he performs the office in my right and is my servant. Quote, YB 11 Edwards, number 4, Roman numeral 4, that is a .1, PL 1 . The driving of the servant is the driving of the master. Smith versus Shepard, that is CRO.ELIZ.710 semicolon M.41 and 42 ELIZ.B.R. period. Under Charles II, it was laid down that the high sheriff and the undersheriff are one officer. Cremer, CREMER versus Humberson, HUMBERSTON, 2 Kelp, KEBLE, 352 in parentheses H.19 and 20 CAR.2 parentheses dot. For all civil purposes, the act of the sheriff bailiff is the act of the sheriff. This is Lord Mansfield, Ashworth versus Kemp, KEMPE, Douglas 40, 42 parentheses M.19 G.III, 1778, period. 2A Corpus Juris Secundum 1. The law of agency is based on the Latin maximum, Quil facile per unum, facile per se, which may be translated as one acting by another is acting for himself. This is based upon Gustafson versus Reykjavik, 263 P.2D 540, 96 ARIS, period 280.278. Corpus Juris Secundum 4, agency. In its broadest sense, it includes every relation which one person acts for or represents another by his authority. It's based upon state comp.mins.fund versus Industrial Accident Commission, 14P.2D 306, 310, 216 CAL.351, period. Yet, defendant has this action dismissed on the claim that the chief of police of Waynesboro has nothing to do with any activity of the Waynesboro Police Department. Number 12, 88 Corpus Juris Secundum 136, trial. As a general rule, where a party consents to the introduction of evidence or where no objection is made to evidence when offered or to a question when asked, or no proper or timely objection, based upon in parentheses Lewis versus Schiffers, SHIFFERS, MUN.APP.67A.2D 269 parentheses, or no proper or timely objection, specifically the grounds thereof is made. Berry versus Adams, APP.71 S.W. period 2D 126, a motion made after the evidence is omitted or the question answered to strike may properly be denied. Terwilligan, TERWILLIGER versus Long Island Railroad Company, 136 NYS 733, 152, APP.DIB, period, 168, comma, affirm 106 NE 1114, comma, 209, New York, NY 522, period. And the plaintiff disposes that of no time during the plaintiff's opening statement to the jury or his subsequent testimony did the defense offer any proper or timely objection to any of the plaintiff's testimony. Yet the defense then moved to strike all plaintiff testimony in toto. No prior objection had been made to any of it, and to obtain a dismissal of this case thereby. Number 13, decision of the court to dismiss this action was also partially based on the cited refusal of the plaintiff to appeal his conviction in Waynesboro District Court on July 16, 1979. But at that time, plaintiff had already filed his motion for judgment with the Circuit Court of the City of Waynesboro, which would have heard said appeal, and said motion for judgment dealt with the question of plaintiff guilt or innocence of the speeding charge, and said question was sub judice in the Waynesboro Circuit Court during the entire period when plaintiff supposedly had refused to refer said action to the Waynesboro Circuit Court. Thus, the Waynesboro Circuit Court dismisses the action for failure to appeal it to the Waynesboro Circuit Court when the question was before the Waynesboro Circuit Court during the entire period. Decision number 14, decision of the court to dismiss this action on the grounds that the plaintiff had refused to appeal his conviction in Waynesboro District Court to the Waynesboro Circuit Court, based the decision in a civil action on a step in criminal procedure. The Oxford English Dictionary, comma, under civil states 16 law distinguished from criminal 1611 COTGR period civilizer versus criminal to change the indictment. To change this indictment to a action to turn a criminal into a civil cause. 1764 Byrne Poor Laws 289 civil implies an offense of a private nature between party and not where the king is party. 1844 H.H. Wilson, British Indies 2395. In the administration of civil law, the panchayats had recourse to while criminal cases were investigated by the British functionaries in person. Thus, the question is raised whether a civil action can properly be decided by the rules of criminal procedure. Number 15. Although he was appealing as attorney pro se, plaintiff was not properly instructed by the court at the conclusion of this action of his right to request that the decision be set aside. Number 16, Corpus Juris Secundum 16, comma, 178, period, parentheses. Quote, statute conferring the police power on municipalities, however, should be construed as not to authorize a unreasonable exercise thereof. Father Basil Lodge versus City of Chicago, comma, 65 NE 2D 805, comma, 393 ILL.246, period. And plaintiff averts that his arrest was a violation which prevented him from engaging in his lawful occupation. 16 Corpus Juris Secundum 224, one has to carry on his business free from all unlawful interference. Based upon Wallace versus Ford, DC TEX.21 F.SUPP.624. Number 17, 16 Corpus Juris Secundum 199. The police powers must at all times be exercised with scrupulous regard for private rights guaranteed by the Constitution, and even then only in the public interest. Oklahoma National Gas Company versus Chowtow Gas Company 236 P.2D 97, 205 OKLA.255, and plaintiff avers that the police powers exercised in his arrest was not in public interest and violated his private rights. Number 18, plaintiff was threatened with imprisonment for debt in violation of his constitutional rights. 16 Corpus Juris Secundum 204, ordinary a debt owed to a government unit is no exception to the constitutional provision. Clark versus City of Cincinnati.com, com.121n.e.2d834, period. Number 19, 5:3 a.m. JUR 435, the courts are generally agreed that an employer may be held accountable for the wrongful act his employee committed while acting in his employer's business and within the scope of his employment, although he has no knowledge. Palmer versus St. Albans, ALBANS, 60BT, period 42713A569. Wherefore, plaintiff respects moves the court to grant his motion to vacate judgment on the grounds that it is contrary to law and the evidence. Meanwhile, at a meeting at Freemasons at a local synagogue, other matters were shelved while a agitated discussion took place as to what could be done about Eustace Mullins. One member stood up and bravely offered that he would do something. A few days later, when I was driving down a side street, a huge Lincoln came roaring out of a business lot and crashed into the side of my car, as my complaint later stated. Number 3, on September 19, 1979, at about 1 p.m., defendant did feloniously and with great force crash his automobile into the side of the vehicle owned and operated by plaintiff and did strike plaintiff's vehicle on the right hand, front, and rear doors, crushing them in, and plaintiff did suffer great bodily harm and property damage thereby. Plaintiff's victim, a Oldsmobile 98 sedan, which was severely damaged, is a rare surviving example of a collector's vehicle known as the Chappaquiddick Special, a model in which a girl met her death during an association with a prominent, upstanding figure, and this vehicle could be worth a large sum during a foregoing political campaign and must be fully restored. Defendant stated to the plaintiff that defendant was at fault and would assume full responsibilities for all actions, but when police were called, defendant stated he did not wish to talk to the police, and as police drove up, defendant fled the scene of the accident. Plaintiff remained at the scene of the accident and gave police full details of the circumstances of the accident, whereupon the investigating officer stated that defendant should be charged with hit and run and leaving the scene of an accident before an investigation was completed. Plaintiff was overcome by intense chest pains, nausea, vomiting, dizziness, fainting spells, and intense back pain, whereupon plaintiff went directly to the emergency room. Powerful fraternal influence immediately went to work for the defendant, who was never subsequently charged with any offense. There were interesting ramifications which I did not learn for several years. First, the driver had been suffering from advanced schizophrenia for years, and under state law, he should have turned in his license. He had avoided this by going to private mental institutions, as state institutions would have required that he turn in his driver's license. Second, at the time of the accident, the defendant had for years been taking a number of powerful drugs, according to his physician, among them dilantin, dilantin, phenobarbital, teoacetaminase, diazoxide, and Haldol. His physician later stated in a sworn disposition that Mr. S had diabetes mellitus type 2. He had a seizure disorder. He had an organic brain syndrome. He had hypertension essential, and he had manic depression illnesses and complication of medication called tardive dyskinesia, resulting in uncontrollable movements. In short, the defendant insurance was inapplicable because of these problems. City officials and attorneys now embarked on a weird 3-year campaign to keep the case from being heard. The result was one of the most amazing legal 3-ring circuses ever recorded in this nation. The attorneys first sent me a 54-question set of written interrogatories, supposing that an attorney pro se I would refuse to answer them, and the case would be dismissed. I answered with 80 pages of single-spaced legal-size forms, which more than answered their questions. The next step was to discover a witness to the accident. They found an elderly black alcoholic and mental patient who claimed to have been drinking in an alley near the scene of the accident with some of his buddies. This good citizen was brought in for deposition. The attorney asked him, "Is this Mr. Mullins here beside you?" Answer, "I don't believe it is. I think he was a taller man." In my opinion, it looked like he was a taller man. Question, do you remember what kind of car it was? Answer, not that. I would not know. It was just an automobile, in my opinion. Although this witness could neither identify me nor my automobile, he was still listed as a defendant's principal witness. I had the court order his police and mental hospital records, which disclosed that he had been arrested for carrying a concealed weapon, that he had been arrested numerous times for being drunk in public, and that he had been sent to the mental institution on detention orders from wife for threatening behavior and abuse of her. Threatening with acts, drinks cheap wine or whiskey all day, was convicted of shooting and maiming a woman, has been on probation since that time. This pillar of the community remained the defendant's chief witness until fraternity ties brought in another one. This relevant and notorious black sheep of our family came in on the deposition to give hearsay testimony that I had told him I ran into such and such car, that it was my fault. I had not spoken to him for months. On cross-examination, I asked him what drugs he was on. He refused to answer. I asked him what drugs he had taken that day. He still refused to answer. By this time, I had filed suit against the attorneys. As and for his complaint, plaintiffs respectfully alleges that the promise of large money, defendant did conspire and act in concert to attack, injure, and destroy plaintiff by speaking, writing, and filing false statements and false accusations against plaintiff, which are false, defamatory, and prejudicial against plaintiff as follows. Number A, as a pretrial conference, defendant so-and-so did state to the court that a plaintiff in his plea had repeatedly referred to defendant's client as being of the Hebrew race and as being of the Hebrew religion, and as that Hebrew, and defendant wished to inform the court that he resented the reference to his client. This allegation, made before 6 persons, was immediately denied by plaintiff, who truthfully stated that nowhere in his pleading had he made such statements. Defendant persisted, stating to the court, I know it's in there somewhere, although those present searching through the file of plaintiff pleadings could not find said allegations. This was typical of the vicious tactics of this outstanding law firm. They immediately filed demurral, whereupon plaintiff cited the statute, liability for words used in proceedings concerning conduct. No lawyer or association or corporation composed of lawyers shall be held liable in any civil action for words written or spoken in any proceeding. Do you hear that, folks? Do you hear this? Unless it be proven by plaintiff that such words were used with actual malice, were false, or were used without any possible or probable cause. I further stated the defendants err in their presumption that a license to practice law is a license to gratuitous attack and injure other persons without a cause. The friendly judge nevertheless granted dismissal to his close associates, whereupon I refiled and forced him to dismiss it again. Although the judge repeatedly tried to aid his colleagues in their blatant attempts to prevent the case from coming to trial, I forced the motion through. At the trial, the attorneys came up with another miracle witness. They claimed that defendant, who had been alone in the car with his wife, had her sister sitting in the back seat. I later learned she had been in Hadassah meeting in Norfolk on the day of the accident. The judge had warned me that the strange statutes forbade the mention of insurance in the accidental trial. The attorneys then announced that their star witness, the black alcoholic, had conveniently been readmitted to the mental institution hours before the trial. I insisted that he be brought in. After a delay of a half hour, he was brought in under heavy armed guards. I then took the stand where the attorneys tricked me into mentioning the word insurance. The senior attorney leaped to his feet, screaming, mistrial, mistrial. I filed motion to vacate order of mistrial, which went the way of all of my motions. Motion to vacate order of mistrial. Plaintiff Eustace C. Mullins respectfully moves the court to vacate the order of mistrial issued on July 29, 1981 in this action for the following reasons. The order of mistrial requested by the defendant because of the inadvertently mention of the word insurance in the presence of the jury, and apparently in violation of statutes prohibiting same, and which was subsequently granted by the court on July 29, 1981, has in effect added a new party to these proceedings, the entity of insurance, and a party whose interests must be safeguarded by casting over them an impenetrable armor of silence. This insurance entity, whose presence, although known to the parties and being known to the court, was not to be made known to the jury, although Virginia statutes which require compulsory motor vehicle insurance for all residents of the state of Virginia, which the members of the jury qualified to be by reason of their being called to service on this jury, was therefore already known to the members of this jury before plaintiffs inadvertently mentioned the compound name insurance agent, presumably revealed to the jury a hitherto unknown and unacknowledged presence in the courtroom. Statutes thus prohibit the mention of an entity which was already known to the court. to the parties and to the jurors, a peculiar presence like Bango at the feast, haunting the proceedings in the manner described by Paul Valery, Valery, in the Cimitero. I'll spell this for you: Cimitire, Marion, Marn, as quoted by William Butler Yeats in A Vision as a seaside cemetery, a recollection, some commentators have explained, of a spot known in childhood. The midday light is the changeless absolute and its reflection in the sea, thus Ophrus de cause eternal. The sea breaks into the epiphany form of life. The monuments of the dead take sides, as it were, with the light and with their descriptions, and the sculptural angels persuaded the poet that he is the light. But he is not persuaded. The sworn devotes not only the dead, but as self-love, self-hate, or whatever one calls it, devours the living also. Thus, plaintiff cause is devoured by the all-conquering worm of an unseen entity, the entity conjured up by the defense, the entity of insurance. 2. By requesting a mistrial because plaintiff inadvertently used in his giving of evidence the compound noun, that is, insurance agent, the defendant effected a transfer of liability and was no longer liable because the entity had been conjured, who simultaneously relieved defendant of further defense of his liability at this trial and transferred it to the entity who was not liable at this trial. Man, oh man, Eustace Mullins went through a lot of shit. You understand that, folks? Number 3, a statute denying plaintiffs the opportunity to give evidence in which the compound noun, insurance agent, is mentioned, thus enthrones insurance corporations and their private stockholders and insulates them against paying dues, awards from their profits, thus granting them a title of nobility and creating a nobility class. Indeed, the Constitution of the United States, Article 1, Section 10, expresses forbids the establishment of such a nobility class. Did you hear that, folks? These are lawyers. They're nobility, you see. They see themselves as esquires. As follows, no state shall grant any title of nobility. The establishment of insurance companies as immune from legal mention not only violates the Constitution, but renders plaintiffs out of law or dead in law. A state statute denying plaintiff the opportunity to give evidence in which the compound noun insurance agent is mentioned violates the Constitution of the United States in these several particulars. That is, creates an involuntary servitude forbidden by the 13th Amendment. That abridges the privileges and immunities of citizens of the United States. That it denies to the plaintiff the equal protection of the laws. That denies plaintiffs due process of the law. The 14th Amendment says no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deny to any persons within its jurisdiction the equal protection of the law. In 16 WALL, period 36, 21, capital L dot ed dot 394, Mr. Justice Field states, it is nothing, this is a quote, it is nothing less than the question whether the recent amendments to the federal Constitution protect the citizen of the United States against the deprivation of their common rights by state legislation. In my judgment, the 14th Amendment does afford such protection and was so intended by the Congress which framed and the states which adopted. Number 5, if such state statutes prevent plaintiffs from presenting evidence before a jury, the question is raised as to whether plaintiffs should transfer his case to a federal court in which each statute would not apply. Number 6, it is well established precept of trial procedure that if the defendant sees that he is losing the case, any opportunity for a mistrial must be seized upon. As occurred on July 29, 1981, it was the defendant's lack of visible defense which caused plaintiff to file a motion for summary judgment on June 9, 1980. A plaintiff reply to grounds of defense filed by defendant. Plaintiff stated on November 7, 1979, defendant had promptly given the name of his insurance agency and the telephone number of said agency to plaintiff, but defendant did not request plaintiff's insurance agent, as defendant had assumed full responsibility and had no intention of seeking any payment from plaintiff's coverage. It was this evidence which is crucial to the plaintiff's case, which plaintiff attempted to inform the jury as to the issues of fact which were to be determined by them. But plaintiff but plaintiff was prevented from doing so by defendant's motion for mistrial. In future hearings of this action, the statute still prevents plaintiff from informing the jury of the facts of the case. Due process would not occur. Plaintiff will be out of law or dead in law. And by not giving such evidence, plaintiff will be guilty of withholding evidence from the jury and of obstructing justice, even if in so doing, plaintiff is following the express instructions of the court and is in accordance with statutes prohibiting the mention of insurance in the presence of the jury. 71 Chorus Juris Secundum 4. What constitutes pleadings? It covers all proceedings taken during the progress of the trial. Snellings versus Darrell, Darrell, 17 GA 141. A. 46 Corpus Juris Secundum 1308. Plaintiff must prove every material allegation or fact in issue. Price versus Pacific Mutual Life Insurance Company 231 II dot comma APP dot 439 comma affirm 144 N dot E dot 161 comma 312 ILI dot 525 comma 35, and I assume this is American Law Review. It says A.L.R. period 730. Plaintiff alleges that he is prevented from proving the facts in issue. B. 71 Corpus Juris Secundum 525. C. Matters eliminated from case or eliminated. A case from case or omitted. The pleadings on which trial it had already determination of whether evidence is admissible. PECOS PECOSRR.CO versus Cruz.CIV.APP.139 S.W.1049 period. Plaintiff alleges that said evidence had already been included in his pleading without objection. C. 71 Corpus Juris Secundum 528. Generally, any evidence is admissible under the general issues which contradicts or tends directly to contradict the allegations which the adverse party must establish to sustain his claim. Sylvius, Lylvis versus Hayes, 6 P.2D 1098, 1100, 138 OR period 418. Plaintiff alleges his evidence is thus admissible. D. 71 Corpus Juris Secundum 2. Statutory provisions, codes of civil procedure, and rules promulgated thereupon are designed to simplify pleadings and to eliminate some of the technicalities of pleading at common law, but generally accepted as modified by such provisions. The common law rules of pleading are deemed to remain in force. That is based upon Stinson, STINSON versus Edgemore Ironworks, that is, DC.DEL.53F.SUPP.864 period in parentheses. Quote, plaintiff alleges that his evidence is inadmissible under common law pleading and that common law procedure overrides any statute designed to protect insurance entities from legitimate awards. 8. Although plaintiff has filed a motion to bar inadmissible testimony before the trial was heard, the defendant did not file such a motion and thereby indicated no inadmissible testimony was expected from plaintiff. Wherefore, plaintiff motion to vacate order of mistrial should be granted. The judge then intimated to me that the attorney wished to negotiate a settlement, but they did not wish to negotiate with me because I was not an attorney. You see how they treat people. He promised that if I hired an attorney, they would settle. Why would you trust these people, folks? Why would you? I was still naive enough to believe this judge. I inquired around and hired a young attorney who would frequently break out into strange equine giggles when we met to negotiate with the defendant's stellar attorneys. He promptly jumped up and ran to the men's room. What's wrong with him? I asked a friend who was sitting in with us. Oh, he's just went to throw up. He replied, it's his first negotiation. When he returned, he promptly agreed that I should pay witness fees to the sister-in-law, some $400. No other negotiations were concluded. I fired him that afternoon and sent the following notice to the defendant. Plaintiff, this is a notice, Plaintiff Ulysses C. Mullins, attorney pro se, hereby serves notice to the defendant that your position at the pretrial conference of April 11, 1983 was openly and positively and definitely reaffirmed that you have refused and continue to refuse to negotiate any pretrial agreements or settlements with the plaintiff, a position you have steadfastly maintained for the past 3.5 years. You are hereby placed on notice that the mounting legal costs of this action are and have been and continue to be solely due to your refusal to enter into any pretrial negotiation with plaintiff, and that on recovery of these costs, plaintiff will demand that such legal costs in this action be deemed punitive in assignment and arrogation to defendant, and thus doubled by decree of this court, because the large costs of this action are and have been continue to be solely consequent to defendant's refusal to negotiate any pretrial agreement or settlement with plaintiff. And plaintiff reiterates that he has been and continues to be willing to negotiate a pretrial settlement at any time since the action was filed on October 1st, 1979, and that any and all legal costs since that date should be retributed, assigned, and arrogated to defendant as his liability because of his refusal to enter into a pretrial negotiation with plaintiff. After months of further deliberation, I succeeded in having the case brought to trial again. The attorneys introduced the deposition from the defendant's physician stating that the defendant was now in a psychiatric hospital and would not be appearing at the trial. The judge then ruled that I could not make any reference to the drugs or schizophrenia and manic depression conditions of the defendant, ruling the entire physical report inadmissible. You see how this is done, folks? You see how this is done? You know, these are devils, folks. It's amazing. 2 days before the trial, the policeman who was my sole witness died suddenly in a local hospital, a medical treatment. I was warned by my automobile mechanic, a black man well versed in the vagaries of a small town existence, that the jury would be stacked. They got this same list, he said. Nobody else ever gets on that list. Without any other witnesses, and denied any opportunity to present to the jury the evidence that the defendant had been driving illegally while under the influence of seizure-causing drugs and suffering from schizophrenia. My case did not take long to present. The judge suggested I bring my car up so that the jury could examine it. The jury filed out, made a lengthy examination of the two smashed inside doors, and returned to the jury room to deliver it. 8 minutes later, they returned to find the defendant. In fact, they had ruled that I had indeed backed my car into the front fender of a defendant's car, which in some manner defying the laws of physics, crushed into two side doors. My, oh my. Wow. So that's the end of the chapter 10 for Eustace Mullins. I don't know if I would have that type of patience with the way they are, folks. Isn't it amazing? There's no such thing as justice, is it? It's just us, you see. So that's the conclusion of chapter 10 with Eustace Mullins here, The Rape of Justice. Thank you for being here. I'm sorry I didn't expect to have all these court numbers being involved in here. But, you know, Eustace Mullins had to be a very determined man to do what he did. And, you know, not many people could have done what he did. And most people today don't even know who Eustace Mullins is. That's why I read his books, because frankly, this guy had a lot more fucking guts than most people did. He did. And it's sad that we live in the world that we live in and the way it is being treated by people who are innocent. So lawyers indeed, woe unto them. Their day is coming. Thank you for being here and have a good night.